We are going to start now. Today is 220th Friday group meeting. The topic is new criminal laws. Whatever changes is brought into these criminal laws, Mr. Justice Nagamuthu is going to speak on this. Before starting, Justice Nagamuthu, our beloved senior and other thing, I request Justice Vasant will initiate and inaugurate our 3-day session. Sir, kindly initiate. You say a few words to energize younger members.
Good evening, everyone. I should be briefest as possible because, like all of you, I am also eagerly waiting to hear Nagamuthu on this topic. It's a very important topic. I congratulate Sheshu for having organized a session like this. I thank Justice Nagamuthu for having agreed to come and speak on it. You know, these are areas where you have to do a lot of preparation to speak. Whenever I am invited for something, I'll say no after some time because I never felt, because these provisions, some of these provisions, they'll have to work it out, and then to give an authentic opinion, it may require time. And therefore, I must thank Nagamuthu for having that. Now, just one word about, I started practice in 1973, ages back, 50 years back when I started practice, I was forced to meet a situation like all of you. The 1973 code had come into existence at that time. I was a raw junior walking to my senior's office. They were always looking this section, corresponding section that was going on. And I think we didn't have the advantage of a speech like this where you could get to know the vital differences. Therefore, I was feeling very obliged. I remember the agony which we had at that time. For everything we had to run to the senior or the next senior and say, what do you do with this? What do you do with this? Now, it's very good that such an eminent person has come here to speak to us, all of us on that. Thank you very much for that. One more point I'll tell you. It has always been felt that our code of criminal procedure is insufficient to do complete justice. At least I completely agree that the criminal procedure code doesn't have the sweetness of the smell of Mother Earth. The criminal procedure code which we've been following over the years is just a legacy of the past, and I don't think there has been any attempt to customize the procedure law and tailor-make it to the needs of our society. It has not been happening at all. So when I heard that the criminal procedure code is going to be modified, all the criminal laws are being modified, I felt elated because I thought something great is going to come about. I am not talking about cosmetic changes here and there. No. When you deal with this, I often hear the criticism, it is old wine in new bottle. This is what everyone says. Old wine in new bottle. Yes, that is my grievance about it. I would have wanted the new code of criminal procedure which would not take in only cosmetic changes but structural changes to ensure that the guilty is punished and the innocent is exonerated. I don't know how you do that. It's a very difficult exercise, but it's my feeling that our code of criminal procedure does not do that at all. We are continuing with the imperial relic of the procedure code because England has changed its law, US has changed its law. Now, so far as India is concerned, a police officer today is even today unable to take the signed statement of a witness. Forget about the accused. You don't trust him at all. We live on a regular diet of distrust against the police officers. We don't record, we don't permit them to do anything. We want them to achieve great things, but we don't arm them with the requisite powers. 75 years down the line as a republic, as an independent country, it must have been possible for a country to develop a police force which is credible. We have not been able to do that. I am not saying tomorrow we can start trusting the Indian police. I am not saying that. But there must have been an attempt to create or to modify a police force. Now call them by any other name. Our police has been so badly misused. And call them by any other name. But they must be able to ensure that justice is done. An ordinary citizen goes to the police station even today for justice. He doesn't come to your court. He comes much later to your court. An ordinary citizen goes to the police station to get justice. Even today, be it a civil wrong or a criminal wrong, he goes to the police station. But very unfortunately, we have not been able to develop a trustworthy, credible police force at all. Well, that I think the fundamental change that should have been brought about. You know that, what is that thing? Prakash Singh.
Police Commission.
Police Commission, tell me that.
Prakash.
Prakash Singh Commission, which in that decision the Supreme Court has said, but we are still continuing with the law and order and the police together. We are not arming the police with requisite powers. We are not able to create a credible police force. I thought when the act comes, there will be very strict provisions by which we endeavor to develop a trustworthy police force. It's not happening. You go even to a country like the Middle East, go to the Saudi Arabia, I am surprised to hear from them that they trust their police. You go to America, ask every citizen, he will say, I trust my police. He calls him cop. The British calls him the Bobby. They trust him. Now, ordinarily, of course, there may be exceptions, but we do not have such a credible police force at all. And I find the new code also does not make any endeavor to ensure that we develop such a police force. Whatever provisions you may make, until ultimately I think the police force is going to be a very important functionary in the criminal justice system. That has not been done. And therefore, I am sure all the various provisions, changes in the provision, he will take us through to the CRPC today, he says, and the other two are very minor changes. But CRPC is the one where you have some major changes, and I do hope that you will all benefit by the 3 sessions that we are going to have. Thank you very much, Sheshu, and thank you, Nagamuthu, for having agreed for this.
Thank you very much, Basant sir. Very wonderful words. Now over to Justice Nagamuthu sir, topmost criminal lawyer of this country. Now he'll take this.
Honorable Justice Basant, Senior Advocate, Supreme Court of India, my dear friend Mr. Seshu, the organizer of Friday Group, and all my mentor, Honorable Justice Karpavanayadu, and all our friends. It is my pleasure to stand before you to speak on 3 sessions in respect of the new criminal laws which have been brought into force on 1st July 2024. Before going into the subject, at the outset, I want to apologize to all of you for I could not do this exercise on 24th as it was originally scheduled on account of certain unavoidable circumstances. Before going for any lecture, more particularly on criminal law, normally I do not so seriously prepare for that, because my experience in criminal law is more than 43 years. Therefore, out of my experience, I can manage any situation. Therefore, I was never serious in making preparation for going for any lecture. But this time, I became very, very serious in my preparation. As a matter of fact, during this vacation, I spent continuously 7 days to read, prepare a chart, and then to understand the law. And again, a very same opportunity was given by our friend Mrs. Seshu, which forced me to again open the book, read it, and compare the same with the old code. Therefore, I got some message to you. I hope that will be useful for you also. Now, today we are going to deal with all the 3 criminal laws. As Honorable Justice Basant put it very aptly, when one code was repealed in the 1973 and a new code came into being, there were a lot of confusions. Similar confusion we are facing because all the 3 major criminal laws have been repealed and new laws have been brought into force. Now, what are these laws? That is, there are some youngsters. Today, I would say that my focus is not on the appellate side lawyers, my focus will be on the trial side lawyers, because who are impacted more today by these laws. They have to create the foundation there. Then only as appellate side lawyers we can do the cases here following the correct position of law. So what are these three laws? Generally we classify the laws into two categories. One is substantive, the other is procedural. Here IPC, which we have been following from 1860 onwards, is the substantive law dealing with the punishments for offences committed. CRPC is out and out a procedural law, which we have been following from 1973 onwards. Indian Evidence Act is yet another procedural law which regulates and guides the courts as to how to appreciate the evidence and to come to a right conclusion so as to do justice to the parties before the court. With that law, we have got experience for about 150 years. Our experience with the Evidence Act is more than 150 years. Our experience with the IPC is more than 160 years. Our experience with the CRPC is more than 50 years. Why I mention this is that during this long period, the courts had occasion to interpret almost all the provisions of all these three criminal laws and to make the law so certain so that any lawyer who enters into trial or appeal will be sure of the legal position so as to place the proper law before the court. Now, the question is whether we are losing that experience of more than 150 years or 50 years, as the case may be, whether we are losing. In other words, whether we are going to lose the interpretations made by the Honorable Supreme Court and various high courts on these provisions. I will say that we are not going to lose at all. These judgments are even today holding good, it will be holding good, and these judgments will be guiding us forever. So don't have that impression that all those judgments interpreting various provisions of these three old criminal laws have become irrelevant. They are even today relevant, they will be relevant forever. Now, coming back to the topic. Today our focus is going to be on the CRPC. Before that, as it was pointed out by our learned senior, I want to concentrate on the repeal and saving provision first, to know as to what is the law that we have to follow in a given case today. Let us go to so far as IPC is concerned, we all know that as per Article 21 of the Constitution of India, being a penal law, it cannot be retrospective at all. So far as the new penal code, that is BSA, is concerned, we can be sure that this is applicable only in respect of the offences which were committed on or after 1/7/2024 and not before at all. So regarding that, regarding repeal and saving, we can have no doubt at all. So far as the Evidence Act is concerned, it will be repealed now. Now, how we are going to apply the same in respect of the cases which were pending before the crucial date and the cases which came into being after the crucial date. So when I am going to take up the Evidence Act, I will come to that repealing provision. Today, I will speak about section 531 of the new code. I think that you all have the new code.
No.
Otherwise, if you do not have, I will refer to that, don't worry. This is a very important provision. That is why our senior was pleased to mention about that first during the introductory remarks. So I will read this provision, 531. Repeal and savings. The Code of Criminal Procedure 1973 is hereby repealed. Okay, no doubt. Then, notwithstanding such a repeal, please underline these words, notwithstanding such a repeal, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued or made as the case may be in accordance with the provisions of the Code of Criminal Procedure 1973. Therefore, as on the crucial date, what are all the appeals pending already filed under the old code? What are all the applications filed under the old code? What are all the trials pending or inquiry or investigation pending shall be continued under the old code as though this code has not come into force at all. So if pending appeals are to be dealt with according to the old code only. Here you may say one thing very peculiar. If you look at before that, you please kindly have a look at section 484 of the Code of Criminal Procedure. 484. I will read that. Repeal and savings. The Code of Criminal Procedure 1898 is hereby repealed. Notwithstanding such repeal, if immediately before the date on which this code comes into force, there is any appeal, replica of what we find in section 531 of the BNSS, any appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with the provisions of the Code of Criminal Procedure 1898 as in force immediately before such commencement as if this code had not come into force. Same section 484 now is repeated as section 531. So what are all the interpretations made to section 484 by this code, by the Honorable Supreme Court, will be applicable to understand and to interpret section 531 also of the BNSS, right? Now, so what are the interpretations? If you closely look at this section, new section, you will find that one word is missing, revision is missing. You see that? Does it mean that all the revisions filed and which are pending as on the crucial date will be done according to the new code? That question may arise because the word revision is missing in this. So one may argue that revision won't come. To obviate this, we have got a judgment of interpreting the old code, section 484. That judgment is Jagir Singh versus Ranbir. That is reported in, I will tell you, AIR 1979 Supreme Court, page 381. AIR 1981 Supreme Court, page 381, where the Honorable Supreme Court has held that the term application includes within its ambit a revision as well. Therefore, a revision which was filed already, pending as on the crucial date, shall be disposed of as per the old code only. Right? Very good. Now, there is another question now. We had elaborate discussion on that also. I had the benefit of getting his lordship's views also on that. Now, there is an appeal pending. In that appeal, or trial is pending, let us take trial first. Trial is pending. In the trial, so now an application is filed by the accused. An application is filed for some relief. Say for example, to recall a witness or for seeking bail. trial is pending as per the old code. It is conducted as per the old code. Now, application used to be made to get some relief in that trial. Relief may be for bail, relief may be, for example, to recall a particular witness under section 311 of the old code. Now, whether the application used to be made under the new code or under the old code because trial is being held under the old code is a question, right? As far as I know, what I heard from Tamil Nadu is that the magistrates are insisting that any application, irrespective of whether it is a old trial or new trial, you have to file only under the new code. That's what they say. For example, if you file an application for bail in a pending case, you have to do it only under the new code, not under the old code. Right? Similarly, they say that even for recalling a witness or to dispense with the personal appearance of the accused on a particular day during trial, you have to make application only under the new code. That's what they are saying. Now, I had a benefit of getting his lordship's views also, and his view is similar to that of my view. So there are two things in this. If an application is made under an independent provision which has got nothing to do more about the trial, then the application is to be made under the new code. For example, if you make an application for bail, it is an independent provision where you want to secure your liberty, which application is to be made under the new code only. Though trial is held under the old code, petition for bail is to be made only under the new code. One. Secondly, suppose an application is made to dispense with the personal appearance of the accused for the day in the presence of the advocate concerned. As per the old code, we have to make an application of 317. Now under the new code, there is a corresponding provision to make an application. Now, since such course, such relief is part of the trial, part and parcel of the trial, now as per the view expressed here by Honorable Justice Basant also, you have to make application only under the old code. Therefore, in those cases where trial is pending as of the day, any application seeking to dispense with the personal appearance of the accused is to be made only under section 317 CRPC, not under the new code. Similarly, if an application is made under for recalling a witness, that should be also made only under the old code, not under the new code. This is our understanding, but there is no state judgment, though this 484 has its own history of more than 50 years. We do not find much of judgments on this because I made a thorough research on that. There is no judgment on this. But we sincerely feel that this is the proper procedure to be followed in respect of applications to be made in respect of the matters which are pending. Similarly, suppose let us say that an application for bail or an application you make under section 317 to dispense with, that is dismissed, then you have to challenge that. Or you file an application to recall a witness, that is dismissed. That application is made under the old code, that is dismissed under the old code. Similarly, when there is an appeal pending already, where an application is made to receive some additional evidence, it is part of appeal. Therefore, that application is to be made under 391 of the old code only. If that petition is also dismissed, then what is the next course available? Petition was filed under the old code. Orders were issued under the old code. So what is the remedy for him? The remedy flows from the old code, or does it come from the new code? That is another question which we have to understand. If for that, you may kindly have a look at subsection 2 of section 531. 2B. All notifications published, proclamations issued, powers conferred, forms provided by rules, local jurisdiction define sentences passed. Please follow this. Sentences passed and orders, rules and appointments, not being appointments, special court, etc., etc., made under the said code and which are in force respectively to have been published, issued, conferred, specified, defined, passed or made under corresponding provisions of this Sanhita. Which means, though you make an application under the old code, though there is an order made by following the old code, it shall be deemed that it was made under the corresponding provision of the new code. Correct? If there is a corresponding provision in the new code, though the order was made under the old code, it shall be deemed by fiction. Yes, it was made under the new code under this particular provision which corresponds to the old provision. Correct? Now, if this deemed clause is applied, then what is the next course available for us now? Is it under the old code or new code? Undoubtedly, by virtue of this provision, your further remedy is only under the new code, not under the old code. Understand this? So this is the basic difference. So though the application was made under the old code, though order was made under the old code, now the further remedy is to work out not under the old code but under the new code. I'll tell you one more example. There is a trial pending already. Trial goes on, it ends in conviction. What is the remedy now? This judgment is deemed to have been made under the new code. Therefore, you have to file appeal only under the new code and not under the old code. Similarly, revision. Any order made already which is revisable under the old code cannot be revised under the old code now because it is deemed that that order was made under the corresponding provision of the new code. Therefore, it is virtually an order made under the new code. The further revision will lie only under the new code. This basic distinction you have to understand by referring to section 531. Similarly, subsection 3, any sanction accorded, consent given under the said code, in pursuance of which no proceeding was commenced under that code, shall be deemed to have been accorded or given under the corresponding provision of this Sanhita, and proceedings may be commenced under this Sanhita in pursuance of such a sanction or consent. Correct? Let us take the example of section 197 CRP. Sanction is required as against a public servant in respect of any offence that have been committed in discharge of his official duty. Now, he applied for consent. Consent was either given or not given. Now, new code has come. What will be the validity of that sanction given already? That sanction is deemed to have been issued under the new code. Therefore, acting upon that, the court can take cognizance of the offence. This is what subsection 3 says. Now, let us come to subsection 3. Where the period specific for an application or other proceedings under the said code had expired on or before the commencement of this Sanhita, nothing in this Sanhita shall be construed as enabling any such application to be made or proceeding to be commenced under this Sanhita by reason only of the fact that a longer period therefore is specified. So this is very simple. Suppose under the old code, 60 days period is given as a limitation to make any application. Under the new Sanhita, it is 90 days. Now, that 60 days period was already over before the commencement of the old code, or commencement of the new code. Can you now say, no, that was over under the old code, now new code has come, therefore the extended period is available? No, you cannot do that. This situation may not arise very often because this will be only for a short period. Now we have crossed almost these limitation periods we have crossed. We are in the month of August now. So therefore we need not worry much about this particular provision. Now, so this is, please understand, as the message to you, what I have said is that in respect of those matters which are pending already, including investigation. Suppose there is an investigation pending already, investigation is to be continued under the old code, charge sheet is to be laid only under section 173(2), but the court will take cognizance not under section 190 of the old code, but under the new code. So trial will be as per the new code. Though occurrence was, see, the date of offence is irrelevant. Date of offence is irrelevant at all. Occurrence was before the commencement of the code. Investigation commenced, going on, new code has come in. Now it is continued under the old code. Now charge sheet is filed under the old code, but court has to take cognizance not under the old code, but only under the new code. Correct? So this is regarding investigation. See, there are some matters where inquiry is held. So preliminary inquiry is now statutorily made here. There are some inquiries. So see, for example, in Lalita Kumari, the Honorable Supreme Court has held that in certain offences like Prevention of Corruption Act and matrimonial issues, there can be a preliminary inquiry held. Preliminary inquiry had already commenced under the old code. The inquiry was going on. Now new code has come into being. Now after completion of the inquiry, the officer finds, yes, here there are materials to register a case. Whether he has to register a case under the old code or new code, he has to register a case only under the new code. Because what shall be continued? Inquiry shall be continued. What was pending as on the data coming into force of the Act? It is only inquiry. That inquiry alone will be continued under the old code, not the investigation, because investigation is a separate proceeding. It commences by registration of a case. Therefore, though inquiry was held under the old code, which was continued under the old code, even after the coming into force of the new code, case shall be registered thereafter only under the new code, and thereafter it will be only the proceedings of the procedure of the new code which will be followed for all purposes. Similarly, appeal, similarly revision, I have said, this is in respect of this particular provision. Why I am more focusing on this provision is that as far as my knowledge goes, there is no uniformity in this country. Each court takes its own views. Now I got two more judgments for you to say on this. That is, Jagbir Singh I have already given to you. Then there is judgment of the Kerala High Court by Honorable Justice P.G. Ajit Kumar. Wonderful judgment. And this matter to be, yes, senior must be very happy because it is his High Court. Yes. Here, His Lordship has referred to a judgment of the Punjab and Haryana High Court. That is the first judgment after the coming into force of the Act. That judgment is XXX versus State of UT of Chandigarh, another, dated 11/7/2024. So first on the first, the Act came into force. On 11th, judgment was delivered by Punjab and Haryana High Court by the learned single judge. He has also taken the similar view which we have now expressed. Correct? That was followed by the Kerala High Court. Kerala High Court has referred to so many other judgments as well, but I don't find that any reference is made to the Jagbir Singh case in that. So, see, there is another judgment also on this aspect. This will also be helpful for you. P. Philip versus Director of Enforcement, 1976 to SCC, page 174, wherein in paragraph 9, other portion I do not want to read for want of time, paragraph 9 alone, just 4 lines. In the present case, the revision application, I was telling you that application includes the revision also. Though the word revision is missing in section 531, it includes the revision also. That's what I told. You may find this in paragraph 9. In the present case, the revision application made by P. Philip was pending before the session judge, but the new code has come into force. In view of section 484(2)(a) of the new code, this revision was required to be disposed of in accordance with the provisions of the old code. Okay. Though the word revision is missing in 484 of the old code and 531 of BNSS, it includes the revision also. So any revision pending already is to be disposed of only under the old code only. This is all about section 531. If you have got any doubt on this, at the end we may have 5 minutes time during which we can discuss about that. Now let us come to the other substantive changes. My senior said cosmetic changes. Yes, I do agree. Only cosmetic changes have been made, not any very effective change has been made so as to achieve that there is fair trial, there is speedy trial, there is conviction of real culprits, and there is acquittal of the innocents. No effort. And this law, in my personal opinion, is not going to in any manner improve the situation. Correct, sir? It's not going to improve because there are so many things out of our experience of all these years. What are all the areas where there are flaws which gives room for delay or miscarriage of justice should have been rectified. They have not been done. Therefore, we join together to say that the changes made have been only cosmetic, and in other words, it is nothing but old wine in a new colorful bottle. That's all we can say. Now, let us go into the provisions. What are the changes now that have been effectively made to some extent? Now, first thing is, in the matter of definition, earlier under the old, but this is not very important, I am just for completion's sake I am saying this. Under the old code, the term bail was not defined. Now it is defined. What is bail is defined, what is bail bond, what is an ordinary bond. They are all defined, they are not of much importance. Now, let us go to this section 6 of the old code. Section 6. Old code. The classification of courts. What are the criminal courts in this country which can be established by the respective government? Section 6 of the old code says, besides the High Court and the courts constituted under any law other than this code, there shall be in every state the following classes of criminal courts, namely, what are the courts? Besides the High Court, indicate that High Court itself is a criminal court when it exercises its power and jurisdiction under the Code of Criminal Procedure, like 439, like 408, transfer power, revisional power, all those things. When the High Court exercises these powers, the High Court itself is a criminal court under the old code. That is again repeated in the new code. Now, what are the other criminal courts which were in our country under the old code? Courts of session, correct? 2. Judicial magistrates of first class, and in any metropolitan area, metropolitan magistrates. Then judicial magistrates of second class and executive magistrates. So these are all the criminal courts as per old section 6. Now what has been abolished? Metropolitan magistrates have been completely abolished. There is no corresponding provision in the new code. Correct? So only these courts, all metropolitan courts, have been now abolished. Metropolitan magistrate courts have been now abolished. And one more court which has also been abolished is assistant session judges. That if you look at section 9 of the old code, the state government shall establish a court of session for every sessions division. Every session division, I'm sorry. Yes. Yes. Subsection 5. where the office of the session judge is vacant, the High Court may make arrangement for the disposal. Correct. 9.2, I'm sorry. 9.2. Every court of session shall be presided over by a judge to be appointed by the High Court. The High Court may, subsection 3, I am referring to Old Code section 9. The High Court may also appoint additional judges and assistant sessions judges to exercise jurisdiction in a court of session. These assistant session judges courts have been now abolished. This is the major change made. Now, so far the assistant session judges are concerned, they have to work within the sessions court. There is no independent power given to that court at all. Every state shall be divided into districts or sessions divisions. A sessions division may consist of one district or several districts. Every sessions division shall have a session court. That is repeated in the new code also. Therefore, in every sessions division, there shall be a court of session presided over by a session judge. We call him as principal session judge. Now, depending upon the workload of that court, the High Court may also appoint additional judges. They are called as additional session judges. Now that provision has not been changed. But assistant session judges have been abolished. What is the effect of this now? Now, as on date, let us assume that there are cases pending trial before the assistant session judges. Today, there are cases which are pending trial before assistant session judges. What will happen to those cases? The court has been abolished. Now, can we say that in view of the saving clause in section 531, the court will continue until the last case pending before it is disposed of? Whether the court will continue, because as per the saving clause, though new code has come into being, no new code has abolished that court is for all practical purposes in existence as per the saving clause. Therefore, the pending cases before that court, before the assistant section courts, are to be continued by the same court. So that court will be in existence. If you want to effectively abolish that court, the session judge has to withdraw those cases which are pending before him and make the same over to an additional session judge, or he himself should try the same. What are the powers of assistant session judge? His powers are very limited. Assistant session judge does not have original jurisdiction to take cognizance at all under 193. Under 193 of the old code, it is only the court of session to which the case is committed shall have original jurisdiction to take cognizance under 193. Cognizance cannot be taken by an additional session judge as well as by an assistant session judge. They do not have original jurisdiction at all. So they can only try those cases which are made over to them as per section 194. Right? Similar provision is now there also in the new code. Corresponding provision is there. Cases are to be made over to the additional court. Here there are cases which have been made over to the assistant session courts. Now, those already made over cases to the assistant session courts shall be continued by him. But if the session judge decides to withdraw, he can withdraw the case and make it over to someone else. So, unless the last case pending as on date is disposed of, either by means of withdrawal or by means of transfer by the High Court, or the case is disposed of, the last case I am saying about, the assistant sessions will be functioning. It is my humble view. Sir also, senior also, from the Lordship agrees? Yes. So it is now full bench. So though junior writes a judgment, two seniors have agreed with me. So this is one thing. Now, So assistant session judge will continue. Similarly, he does not have revisional jurisdiction on unless the case is, the revision is made out to him by the section judge. So those revisions pending before assistant section judges will be continued because of the saving clause, and unless they are again withdrawn and made out to some court or they are disposed of, the court will continue to function. This is in respect of assistant session courts. Now let us take the case of metropolitan magistrates. Let us come to that. Metropolitan magistrate courts have been now abolished under the new code. There is no metropolitan magistrate. But in their place, now all the magistrates shall be judicial magistrates of first class or second class, as the case may be. So let us take, so I am told that Delhi High Court has notified all these metropolitan magistrates in Delhi as judicial magistrates of first class. I hope that many high courts have done that. So now, here is a metropolitan magistrate originally appointed. Now he is redesignated as judicial magistrate of first class. Now there was already a case pending before him when he was metropolitan magistrate. Whether he will dispose of the same or conduct the trial and dispose of the same as metropolitan magistrate or judicial magistrate. This problem will arise. One may argue that as per section 531, this abolition has not taken place so far the pending cases are concerned. Therefore, a magistrate, he will be only a metropolitan magistrate. He will continue to try the cases as metropolitan magistrates. And in respect of old cases which are pending under the old code, can he try them as judicial magistrate? His new avatar has come into being only from 1/7/2024 and not before. So therefore, my humble view, because the matter is yet to be settled by the Honorable Supreme Court, unless this provision comes to be discussed by the Honorable Supreme Court, argued by the Supreme Court, and it is settled, this confusion is going to be there. Because this confusion was not there when the old court came into being, because no court was abolished then. For the first time they have done this. Therefore, this confusion will remain for some more time until a finality is given by the Honorable Supreme Court by an authoritative judgment, by either by reading down or to clarifying that in respect of the old cases pending already, he will be only a metropolitan magistrate, and in respect of the new cases which he has taken cognizance after 1/7/2024, he will be judicial magistrate. This, as I already told, this problem was not there when 1974 code came into being after repealing 1898 code. For the first time this problem has now arisen. Though these courts have been now redesignated as judicial magistrates of first class, my humble view, subject to your understanding and subject to the views to be expressed by our seniors, is that these metropolitan magistrates exist today and there is no abolition insofar the old cases are concerned. Please keep this in mind. Therefore, trial is to be held only as per the old code. He is only a metropolitan magistrate and not a judicial magistrate so far the old cases are concerned, is my view. Let this be settled. So these two things are relating to abolition of some courts under the new code. Now let us go to some more provisions. I don't think that we will be in a position to complete. So anyhow, because it is very important, and I think that I can devote some more time tomorrow also on the very same subject. Now let us, we have to deal with the power of arrest and other things, what are the changes made, that I think that we can cover tomorrow. So for the sake of continuity, Let us go to the investigation part. Old chapter 154 and new chapter. There are a lot of changes made in this. Therefore, I want to concentrate on this provision, that is old code section 154 and new code 173. Yes. One 154 of the old code speaks of registration of FIR, right? Now the corresponding new provision is 173 in BNSS. And there is marked difference between these two. Please kindly closely watch this. I will read first the old code. Every information relating to commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it. 1. And the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. Please underline these words. The state government may prescribe in this behalf. So, whenever any information related to cognizable offence is made, the police office, the officer in charge of police station is bound to enter the same in a book to be specified by the state government. The book which was specified under D is nothing but the FIR book. Therefore, what we say is that whenever such entry is made in the book, we say case registered, FIR is registered. This is under the old code. Under the old code, for quite some time, there was some doubt whether a police officer, whether if a complaint is made to a police station which has got no territorial jurisdiction over the place where the offence has been committed, can register a case. So one view was, no, case can be registered only by the jurisdictional police officer and not anybody else. This was one stand taken for quite some time. Then the Honorable Supreme Court, some 20 years before I think, made a new concept saying that no, don't drive the parties to go to the jurisdictional police. If a complaint comes to any station house officer, you receive the complaint, enter the same in your book, you register FIR. That FIR will be known as zero FIR. After registering the zero FIR, the case is to be, the FIR is to be transferred to the jurisdictional police. So ultimately, who will investigate? Not the officer who registered the zero FIR. It is only the jurisdictional officer who will investigate the case after the zero FIR is transferred. This position was followed by our police officers for quite some time. Now, then came Lalita Kumari, constitutional judgment. There was confusion whether the police officer is bound to register a case based on the allegations in the FIR without having any other option but the question. There was one view saying that he is bound to register a case, he is not concerned as to whether the information is right or wrong or reliable or not. He is not concerned with that at that stage. There was another view which was also taken by some high courts saying, no. So he is not a machine to act in a mechanical fashion. He can hold some inquiry. We call it preliminary inquiry. After such preliminary inquiry, if he finds some substance making out a cognizable offence, then only he can register a case. So this was the second view going on. So this ultimately was referred to a constitutional bench in Lalita Kumari, where the Honorable Supreme Court has now settled What is the view taken by the Honorable Supreme Court? It is a rule that case is to be registered if the allegations in the complaint, or in the information makes out a cognizable offence. Correct? Case is to be registered. But the Honorable Supreme Court has carved out certain exceptions. There are some offences, they have catalogued those offences as well in the judgment itself. There are some offences such as prevention of corruption where there can be a false complaint made against a very honest officer. So we cannot allow such a honest officer to suffer by having a FIR registered against him. Similarly, in matrimonial offences, false complaint can always be made. So therefore, we cannot direct the police to register those cases because it will have its own very serious impact in the family. There are similar offences. Therefore, the Honorable Supreme Court said very rightly that in respect of these kinds of offences, the police officer is given a power to hold preliminary inquiry. But the preliminary inquiry is very summary in nature. The purpose of preliminary inquiry is not to find out the truth. It is not investigation at all. It is only preliminary to the investigation. Then what is the scope? The scope is to find whether there is any material to proceed further by registering a case. In effect, whether cognizable offences are made out from these allegations. For that limited purpose, we can hold a summary inquiry, summary preliminary inquiry. This is what Lalita Kumari said. It was by a constitutional bench. We are following that. Now, this is regarding the old section 154 CRPC. And there are other areas in 154 which I will come to that later. Now, will make a comparison of the new code now. New code, section 173. Yeah. Information in cognizable cases. You see what are the changes made in this. Every information related to the commission of cognizable offence, irrespective of the area where the offence is committed. This is the new introduction. New introduction. Earlier it was not there. What was done as a zero FIR is now statutorily made in this provision itself. Therefore, that judgment has been appreciated. That judgment has been followed. Now, therefore, in order to obviate any doubt on that, they have made this provision, they have inserted this phrase in section 173 which says that irrespective of the area where the offence is committed may be given orally or by electronic communication. This was earlier, it was not there. So that is why the lawmakers claim that we have introduced the science and technology more into this new law. Actually, it is not so. I got my own reservations. My senior will also have similar reservation. So let us not go into that controversial areas. So what is done? By electronic communication to an officer in charge of a police station, and if given orally, it shall be reduced into writing, old provision. Then by electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it. This is the problem. If a person comes directly and makes a complaint, that is information, no difficulty, you will enter the same and register a case in the book, that is in the FIR book, under the old code. In the new code also, when any person comes with an information making out a cognizable offence, no difficulty in registering FIR because same provision is extracted, it is repeated. What is the change made? Change made is in respect to electronic communication. Suppose I send one message by means of WhatsApp, one message saying that here is a murder which I saw. One person, aged about 30, was killed by shooting by another person of 50 years old, around 50 years old. I give this information by electronic mode, by means of either SMS or email or by means of WhatsApp. I am sending it. Now, what is the duty of the police officer? He has to bring the same on record. See the language used. By electronic communication, it shall be taken on record by him. Already he has taken the same on record. After taking that, what he has to do? He has to enter the same, he has to register FIR, is it not? Now, problem is the further qualification. It shall be taken record by him on being signed within 3 days by the person giving it. So he will take it on record only after the person comes to the police station, makes a signature. Otherwise you can't do anything. Suppose the person never comes to the police station. What is the duty? I will send a message. So I have gone to Singapore. Why should I come within 3 days? I can't come. I see it in front of the airport. I send a message as a very duty-oriented citizen of this country. I send a message. I send one email. I go to Singapore. I return after 20 days or 25 days. For these 20 days, what will be the fate of the information that I have given? You say that you will receive it on record only if I sign it. When? That too within 3 days. If I do not come for 2 days, you keep it and the dead body will be lying there. What will happen to that? This is the first information, earliest information which I give. It is not authenticated because I have not signed that. Therefore you say, no, don't register anything. Let him come, let him sign. Then you enter the case. Let me give yet another example. I send a message, I have gone. Some other person comes later to the police station. He says, yes, I saw this occurrence. He gives an information. Now there are two information. Which is the first one? Whether my information is the first one or his information is the first one. Assuming I come to the police station 1 day thereafter, I make my signature. It is an authenticated information. Mine is the first one in point of time. Therefore, the police officer has to register a case on which? On my information or on the information given by the second man who came sometime later after me, which is the earliest information upon which the case is to be registered. They want to say that we want to introduce the technology. Already introduced. Why this then? Why this then? So what is the position under the old code? Suppose someone gives information through phone. He says, cryptic information. Sir, here one person was shot dead. Phone cut. Can any case be registered? No. This is also a communication made through electronic mode. Any case can be registered on that. Can it be? No. Then what is the position of the old code? What is the understanding of the law? The Supreme Court held on several occasions in such an event, you enter the same in the general diary. Don't register any case because it is only a cryptic information. But at the same time, there has to be a record to show that such information was received. Such information was received. There has to be a record. Therefore, Supreme Court said, enter the same into the general diary. Don't register any case because it is very cryptic information. It may be even false. It may be even absurd. Therefore, after having made entry into that, you go to the spot, verify. Yes, it has happened, dead body is lying. Then take statement from someone from that spot or anybody who comes forward, then register a case on that information. Now there are two informations. One which is a cryptic one, which is not authenticated. Entry is made in the GD that does not form part of the FIR. The FIR is registered only on the second information. That is deemed to be the first one in point of time. Though practically, as a matter of fact, it is the second information, we treat the same as first information upon which case is registered. This was under the old code. Now what is the improvement that you have made in the new code? You have further complicated. So what should have been done in this? What should have been done? You should have said that any such information which unauthenticated is received through WhatsApp or this thing, that thing, you make entry in the general diary, go to the spot, verify, and if you are certain to get the information, then you register a case on that information. Now what is the position now? What the policeman will do? If any electronic communication is sent, I do not understand this provision at all. This is one thing. Now let us go further. Let us go further. See, second provision. Thank you, sir. You can continue.
Please continue, sir. If you want, you can go, sir.
You continue?
Yeah, we will
I
continue,
will
sir.
do it for another 10 minutes.
You can leave, sir.
Sir, I got some meeting.
I have to go. I'll take it.
Please. We will discuss about all this tomorrow. Yes, sir. Yes, sir. Yes, thank you.
Yes, sir. These are the
Yes.
books you can have.
No, I have.
Okay.
Brother, can we continue for another 10 minutes?
Please, sir.
If all of you agree, I can continue.
Yes, sir.
for-
Absolutely, sir. So much of effort, sir. It's a minimum.
No, no, let me complete this provision.
The
at
flow
least.
should continue, sir.
We have got many more things to say tomorrow. Let me complete at least this provision. Okay?
You will follow the
Okay.
information.
Now, let us go to the second provision. By electronic communication, I have said, then next, second, provided that in the event that the person against whom an offence under section so and so, 64, 65, 66, 66, etc. is alleged to have been committed or utterly or permanently, mentally or physically disabled, then such information shall be recorded by police officer at the residence of the person seeking to report such offence or at a convenient place of such person's choice. These are all, we have got no grievance over there. Then, the recording of such information shall be videographed. So, would it be practically possible? Point 1. Suppose it is videographed. What for are you going to use it? Are you going to use it as a piece of evidence at the time of trial? What are you going to do with that? Whether the accused can use it, and whether this requires the certificate under section old 65B and the corresponding new provision. It requires any certificate. Suppose the accused wants to use that videograph. Well, certificate under 65B of the old code and the corresponding provision of the new code is required or not? This we will cover when we deal with the Evidence Act as to what are the changes made in respect of section 65A and 65B of the old Evidence Act. We will deal with that. Let's see, then 1. A copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant or the victim. Now electronic communication comes. So copy is to be given to whom? Whether it will be given to, is it mandatory? No, it should be consumed only as directly. Therefore, the person wants, copy can be given, or else it need not be given. Now, another change made is this. We kindly see this. Subsection 3. Without prejudice to the provisions contained in section 175. Please mark 175. I am going to immediately refer to section 175 as well. On receipt of information relating to the commission of any cognizable offence which is made punishable for 3 years or more but less than 7 years, the officer in charge of police station may, with the prior permission from an officer not below the rank of the deputy superintendent of police, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry. Preliminary inquiry was upheld or made as a law in Lalita Kumari, which I have already told you. Now, statutorily, they are introducing one concept known as preliminary inquiry. Under this provision, whether this preliminary inquiry and the preliminary inquiry held in Lalita Kumari are one and the same, or different. In my perception, they are different. Reason is very simple. As per Lalita Kumari, irrespective of the quantum of punishment that is imposable, in every case which are catalogued, there can be preliminary inquiry. Correct? Preliminary to what? Preliminary to registration of a case. This is to be done before registration of the case. That is Lalita Kumari. Now here, this preliminary inquiry dealt with in subsection 3 is prior to the registration of the case, after the registration of the case, after the registration of the case, or before. Please kindly very closely have a look into the provision. There is a lot of confusion in this again. We are going to create confusion unless and until it is settled by the Honorable Supreme Court by reading it down properly. Just see. Considering, see, the offence must be punishable for more than 3 years. 3 years or more. 1. But less than 7 years. Only in respect of these offences, irrespective of the offences mentioned in Lalita Kumari, we can hold preliminary inquiry. If the offence is punishable for less than 3 years, no preliminary inquiry. If it is more than 7 years, no preliminary inquiry. Now, take the case of the Prevention of Corruption Act. The offences are punishable up to 7 years. Lalita Kumari says that you hold preliminary inquiry. This provision says that only if it is less than 7 years, you can hold preliminary inquiry. Right? Therefore, whether Lalita Kumari, which is a constitutional judgment, will hold the appeal, or this will hold. If you are going to say that Lalita Kumari principle used to be applied, then this provision used to be differently interpreted. How? Lalita Kumari, as I pointed out to you, speaks of preliminary inquiry before the registration of the case, and that too for the particular registration of the case. But this provision says it is not for the purpose of registration of the case, it is after the registration of the case. Please kindly see the words. See, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists prima facie case for proceeding in the matter within a period of 14 days. Within a period of 14 days from the date of registration of the case, you can hold preliminary inquiry in these cases. Next one is very, very important. Or proceed with the investigation when there exists a prima facie case. So, whether to proceed with the investigation or not, you are holding preliminary inquiry. So, Lalita Kumari said that before registration of the case, you hold inquiry, preliminary inquiry. Purpose? To ascertain whether case is to be registered or not. But this preliminary inquiry is totally different because it says that after registration of the case, you hold a preliminary inquiry. What is the purpose? Purpose is whether to investigate further or not. That's what I am reading. Proceed with the investigation. Proceed with the investigation when there is a prima facie case. So preliminary inquiry is for the purpose of deciding as to whether to continue the investigation. For that you are given the preliminary inquiry. I don't understand. After the registration of the case, what follows is nothing but investigation. But quote this new BNS says, no, you can also hold a preliminary inquiry. Preliminary to what? Not preliminary to registration of the case, preliminary to the commencement of investigation. Now, one difficulty will be there in this. Suppose such an inquiry is held, sir. Case has already been registered. Officer says, no, I am not investigating, I am only holding inquiry. Statements are recorded. Whether these statements would fall within the ambit of old section 161 and the corresponding new provision, so as to be hit by section 162 of the old code and the corresponding new provision, because as per that provision, any statement made during the investigation is hit by section 162, it falls under 161, therefore it cannot be used for any purpose. Can you tomorrow say, here this statement was not recorded during the investigation, though FIR was registered, statement was not recorded during the investigation, and therefore this would not fall under the mischief of section 162 and the corresponding new provision. Therefore I will use it. 161 says that signature should not be obtained. So in the preliminary inquiry, his signature can be obtained or not? Persons are said that we are not establishing a credible police department, and therefore we are not showing any credibility to the police. True. Here in this case, you please tell me the dichotomy. Whether the statement recorded during the preliminary inquiry as per subsection 3 after the registration of the case would fall within this mischief, or whether the police officer can get the signature of the witness. Can it be used for any purpose, like for contradiction or for corroboration? Can you use it as substantive evidence? These are all the issues in respect of subsection 3. Now we have to cover the rest of the portion of subsection 4 and other corresponding provisions for want of time, and so you may not have patience to sit for beyond this time, because tomorrow you are all will be busy in your cases. Therefore, today's lecture we have covered one full provision 531, and I will correspond the same as and when I refer to any other provision also. So regarding this 173 equivalent corresponding to section 154 of the old code, I would now again take you to 531, that repeal and saving provision. Again I would take you to that. We have not covered this 173 fully, and tomorrow I am very hopeful that I will be a little fast and cover investigation, trial, appeal and revision. With that I am very, and we have got other things. Bail is there, remand, lot of changes have been made. See, IPC and Evidence Act can be covered in one single day, in one session. There are no lot of changes made. But this procedural law, the CRPC has undergone lot of changes. So therefore we have to concentrate more on this, because this is very, very important for the trial side lawyers, because they are the foundation, they are the pillars. They are going to take defenses, they are going to conduct the trials tomorrow. There should be no error. Therefore at the outset I said that my focus today is for the benefit of the trial side lawyers. Okay. So therefore I think with all your permission, today I complete our discussion with this, and I am hopeful that we will meet tomorrow by 4 o'clock.
4 p.m.
We will continue from where today we stand. And before concluding, I thank Mr. Seshu sir and for having given me this wonderful opportunity, and Mr. Vasant and Mr. Karpurunayagan, the senior people, for having encouraged me. And above all, you are in large numbers here at this 5:30. Almost it is going to 5:30. Leaving all your office work for tomorrow. So I am very thankful, I am very grateful